Good morning, everyone. My name is Mitch Coons. I'm the communication manager with the Clallam Economic Development Council. Colleen is out of the office today, so I'll be taking the lead on the coffee chat. And really excited today to be joined by Clallam County Prosecutor Mark Nichols. He joined us despite our Zoom technical difficulties to get started this morning. So I appreciate everyone pivoting and joining the new Zoom link. But we're off to the races now. So I'm going to give Mark the lead here and go ahead and jump in. But before I do, if you could remain on mute during the call, definitely helps cut down on background noise. And if you have any questions, I'm sure Mark would be happy to answer them. So go ahead and put them in the chat or raise your hands and I'll call on you. And the meeting is recorded, so it will be up on our website later today. Without further ado, Mark, go ahead.
Great. Thanks, Mitch. And I may enlist your assistance in screen sharing in a moment,
Yeah.
only because I don't see a link through which I can do that. Uh, Pending that, I'll just introduce myself to folks that I don't know. Good morning, everyone. My name is Mark Nichols. I'm your duly elected county prosecuting attorney, and it's my pleasure to share some time with you this morning via the Zoom platform and provide an update regarding some of the pertinent issues and goings on in the criminal justice system and your county prosecuting attorney's office. And I have a PowerPoint presentation prepared.
Yeah, I enabled screen sharing. Are you able to share with that button at the bottom? It says share.
Bear with me here. Yes. Let's try that. Can folks see that all right?
Yeah, it's pulling up now. Yes, we can see it.
Okay, great. And I'm going to go ahead and start this from the beginning.
Good.
Okay, wonderful. We are underway. So again, greetings everyone. This is about a 20 slide deck PowerPoint presentation. I would certainly welcome any questions from the group, either during the course of the program or at the conclusion of it. And so without further ado, I'll start by touching a little bit on your county prosecuting attorney's office. For those who do not know, the Office of County Prosecuting Attorney is a constitutionally mandated office by virtue of Article 11, Section 5 of our state constitution. In Clallam County, the office is designated as nonpartisan by virtue of a 2020 amendment to the county's home rule charter. Prior to that time, the office had been designated as partisan, as it is in most of the 39 Washington counties. A supermajority of voters here decided that it would be beneficial to get politics out of the office. I think because they really just wanted to have a prosecutor who would focus on the law to the exclusion of partisan policy influence. And so we do that on a daily basis in your office. Our statutory duties are set forth in RCW 3627020. That's where you'll find the functional equivalent of the job description for the county prosecutor in each of the 39 Washington counties. While prosecutors are known for a number of different things, probably prosecuting crime is at the top of the list just because that's what media tends to take an interest in and what people are oftentimes most curious about. More quietly behind the scenes, we also serve as in-house counsel for county government. And so in that capacity, we advise the County Board of Commissioners, the county's elected officials, appointed department heads, county boards and commissions, and even individual county employees to the extent they have a question that pertains to the course and scope of their employment that is legal in nature. We do have an office mission statement, which is to seek the just result. This is something that I developed with input from the crew in the office back in 2014 when I assumed the helm. Prior to that time, we did have a mission statement, but it was rather long, drawn out, and a bit clunky, and I'm not confident that everybody even knew that we had one. So this is something that's shorter, pithier, a little easier to remember. By way of staffing, when we're fully staffed, we have 13 attorneys. who collectively have over 115 years in criminal prosecution experience, 35 years in criminal defense experience, 35 years of government civil practice. And we also have a support staff division comprised of about a dozen individuals who help keep things moving behind the scenes, two victim witness coordinators who help crime victims, survivors, and witnesses navigate the criminal justice system as we go about prosecuting cases. We don't have investigators, and this is something that I like to underscore only because many people operate under the misapprehension that the prosecutor's office investigates crime when in fact we don't. Instead, we refer to the wisdom of the men and women of law enforcement to employ their expertise in doing that. We have 4 divisions, including a criminal division, a civil division, a support staff division, and our victim witness service division. And collectively, we are the largest law firm on the North Olympic Peninsula. I'd like to, I think, start by talking a little bit about indigent defense. This is something that I've spoken to in the past. However, I don't think that I can talk about it enough given the impact that it's having on the broader system. And so to introduce this, I'll state that ever since the US Supreme Court decided the landmark case of Gideon versus Wainwright in 1963, indigent criminal defendants, that is, defendants who are not in a position to be able to afford an attorney on their own, have held a constitutional right to legal counsel to representation. And that Sixth Amendment right conferred through the US Constitution, as enshrined and underscored through the Gideon v. Wainwright case, is applicable to the states through the 14th Amendment Due Process Clause. And the Washington State Constitution also has a provision in Article 1, Section 22 that guarantees a right to counsel. There was a 2017 study that was done addressing right to counsel services in the 50 states, and it was from a group called the Sixth Amendment Center that I think does a pretty good job of summarizing how the various states approach indigent defense as a broad topic. And I'm going to pause for a moment. Mitch, can you hear me all right?
Yeah. Yeah.
Okay, sure. Okay, it was a radio silence and I can't see the background, so I'll continue then.
We're all just really interested hearing
Okay.
it.
Okay. And so from a snapshot in time standpoint, at least back in 2017, and this is the most recent accurate data that I've been able to find, in 21 states, public defender services are regulated by commissions at the state level. 13 states regulate only certain aspects of public defense, and 16 states provide no direct oversight over public defense. 27 states fully fund public defense services, 11 provide some cost funding towards indigent defense, and 12 states provide minimal or no funding. The reason this is important to understand is because it helps to frame and underscore that Washington falls into the no state oversight and minimal or no state funding category. And so our approach to public defense is a little different from what exists in the majority of other states. There have been a number of changes that have been occurring to indigent defense over the last couple of years in particular, which are going to have significant impact on city and county governments on the one hand, and the provision of indigent defense services and even prosecution on the other. And so I'll start by noting that in March of 2024, the Washington State Bar Association Board of Governors adopted revised indigent defense caseload standards, which apply to cities and counties. And under state law, specifically RCW 10-101-030, these standards, quote, should serve as guidelines to local legislative authorities in adopting standards. And so for that reason, county boards of commissioners, city councils around the state of Washington really need to pay attention to the WSBA standards, understanding that if they depart too far from these standards as recommended guidelines, they can invite liability that can require them to pay out substantial sums of money taxpayer dollars in particular. And so county commissioners and city councils tend to focus on the WSBA standards. At the same time, about a year or so later, in June of 2025, the state Supreme Court adopted new indigent defense standards through court rule, and these apply to attorney practitioners. And so, on the one hand, we have the WSBA Board of Governors guidelines that are being focused on by county commissioners and city council members. On the other, we have attorney practitioners who are laser focused on the court rule amendments that were affected by the state Supreme Court. And so the changes that have been made over the last couple of years, in some, affect a few core purposes. Number one, they cap defense workload. Number two, they increase funding and resources for the defense. They do present what I would characterize as a affordability challenge or even a crisis for local governments, counties and cities in particular. This has been characterized by many as an unfunded mandate issue, which is currently being litigated. The state is being sued under the allegation that it has pushed down the cost of providing indigent defense services to local governments and is not paying its fair share. Because that litigation is pending, we don't yet know the outcome. Suffice to say, it's an issue that may well make its way all the way up to the state Supreme Court and potentially beyond. The standards that have been adopted contribute to a criminal justice system imbalance. And the reason that I say that is because while the WSBA focused on indigent defense, as did the state Supreme Court, they didn't focus much on prosecutors. And so they've created workload standards for one half of the equation to the exclusion of the other, which again lends itself to an imbalance with respect to workload and how the system is going to come to function. And I believe most concerningly, the new standards are going to accelerate a supply-demand challenge and a tipping point within the broader criminal justice system. And this is because under the new standards, it is going to be the case that we're going to need to have more indigent defense attorneys to keep pace with demand in order for the system to operate and for public safety services to continue to flow at a level that I believe meets with public expectation. There are a few challenges presenting, including that Washington is contending with an ongoing attorney shortage. And so for that reason, we're having a difficult time attracting and retaining public defenders around the state, including here in Clallam County. And if we can't attract and retain enough public defenders, and that comes with a price tag, of course, we're going to invite some consequences that are going to be troubling, I think, to the traveling public. And those include that in circumstances where the prosecutor's office files criminal charges and there's not sufficient defense resource available, we may well find ourselves going down the path of other Washington counties and seeing the courts dismissing a number of cases, which is going to result in delayed justice and likely some public frustration, in my opinion.
Why do you think there's an attorney shortage in Washington State? I'm sure there's lots of factors, but
Well, I've read a few different articles from the State Bar Association on the one hand, a law review article on the other. Washington State is, I suppose a few things might contribute to it. What I read is that starting just prior to the pandemic, we started to see a dip in the number of attorneys who are graduating from law schools around the state, taking the bar and then going into the practice of law. The data on that is a little thin from my standpoint, but I've read it from a series of periodicals. They just haven't tied any data to prove that out. Secondarily, I'm led to believe that as to the number of law grads who graduate, take the bar, and pass the bar, few of them are going into public service, likely because of the high cost of law school. And so instead, they're opting to go into the private sector where the compensation is more lucrative and allows them to pay off their law school debt and actually get ahead in life. For rural counties, there's some additional challenges, I think, that accompany the geography in which we exist. And so for Clallam, which is not just a rural county, but somewhat of an outpost county, as I've described it to some, it takes a special sort of person to want to come here and stay here early in their legal career. And so we've seen through the local bar a number of retirements occurring over the last decade for folks who've been around. You might have noticed that. And there's a substantial hole in our local private sector bar, and ongoing challenges for the prosecutor's office and even at times the public defender's office in attracting and retaining attorneys. We are also contending with a dog eat dog business environment in relation to Washington cities and counties, some of whom have significantly increased compensation packages, and they are able to offer something more attractive than we are here. And so for people who have to be able to pay the bills, including law school debt, it's not uncommon that we will see them go to larger jurisdictions or even same or smaller size jurisdictions that have decided to prioritize compensation at a higher price point. So I think those are a few of the reasons that are contributing. There are probably more. More time will likely need to pass before we have a better picture of what's driving the shortage. I just know that it does appear to be the case that it's happening.
Got it. Yeah, that makes sense. Sounds like a fundamental issue that's trickling up. So yeah, thank you.
Yes. And the same issues that I'm sure this group has heard about surface in relation to this. And so we have, over the last several years, interviewed people who wanted to come work in the prosecutor's office. Among other explanations provided from folks who received a contingent offer employment were that the breadth of healthcare wasn't sufficient based upon their family need, pre-existing medical conditions, those sorts of things, the need for specialty practice. The cost of housing here has also been surprising to some attorneys who we've hired, who've moved here from other areas. They've just remarked that they thought it would be less expensive to live in a more rural area. And so they're discovering, sometimes the hard way, that this is a pretty desirable place in which to live for those who want to be here, and that has driven the real estate market up. And I'm sure there's folks here who know a lot more about that than I do. Shifting gears, I'd like to talk briefly about bail reform efforts. This is something that's a hot topic. Rarely a week goes by when I'm not asked rather, by somebody in the community about bail being set in a particular case. And so from a fundamental standpoint, I think I'll start by underscoring that bail is set by judges within the criminal justice system. In the superior court setting, that's a superior court judge on felony cases. In the district court setting, where we prosecute misdemeanors and gross misdemeanors, that's going to be a district court judge. The prosecutor makes a bail recommendation. At the same time, there's usually a defense attorney who's making a counter recommendation on the other side, and the judge takes all of the information presented, considers that, and then renders a decision regarding whether to impose bail, and if so, in what amount. And the setting of bail has traditionally been addressed through a court rule, which is currently under revision or review by our state Supreme Court, and will potentially be changing in some pretty significant ways. And so at present, there are some bail reform proposals that have been brought forward by various defense organizations. They are currently pending before our state Supreme Court. And the proposals would change the requirements of the court rule addressing bail by replacing the current standard of likely failure to appear with high likelihood of willful flight from prosecution. And so a bit further about that point, at present, prosecutors have really three things that we can focus on in making a request for bail. Understanding that there is a presumption for release in criminal cases. Stated somewhat differently, unless the prosecutor can overcome the presumption for release, a person gets released on mere conditions without bail being imposed. In order for prosecutors to successfully argue for the imposition of bail, we either need to point to a flight risk concern in relation to the particular defendant before the court, or we need to be able to argue that their release absent bail increases the risk of the individual committing a violent offense within the community. And last but not least, we can make arguments sounding in interference with the administration of justice. And so, under the proposed changes, the likely failure to appear current standard would be replaced with a high likelihood of willful flight from prosecution standard instead. And I'll talk more about why that's significant in a moment. The proposal before the state Supreme Court would also enact a $200 cap on bond and warrant amounts for most misdemeanor offenses, excluding domestic violence offenses, driving under the influence offenses, and any attempt to commit a Class C felony, which is treated as a gross misdemeanor under state law. And that can only occur when there's a finding made under the newly amended willful flight prong. And so the organization to which I belong, known as the Washington Association of Prosecuting Attorneys, read through the proposal that's been brought forward by the defense bar, and we submitted written comment to the state Supreme Court articulating some concerns that we had about this. In particular, we pointed out that the proposal before the state Supreme Court would create an unworkable standard insofar as a prosecutor will rarely know why the defendant did not appear. And so if we're being held, or if it's suggested that we're going to be held to a standard of needing to demonstrate willful flight from prosecution, that will require us to be able to understand the motivation behind why a person didn't appear in court. And the reality is that only the defendant is going to know why they didn't appear. The prosecution will rarely be in a position to know that. We also expressed a concern in that $20, 1/10 of the $200 amount that's proposed, is largely insufficient to ensure the appearance of a person who willfully flees from prosecution. Most people can afford $20, I would submit, and if they really don't want to find themselves in jail, paying $20 is all it would take to get out. Ultimately, we believe that the proposal before the state Supreme Court would likely result in more court hearings needing to occur with people cycling in and out of jail. And that would fuel what some refer to as a catch and release cycle and increase court congestion, which is something that's a challenge for us already. And so we're not interested in supporting a proposal that will create more of it. More concerning is that the exceptions to the bail cap, that is the $200 cap that's suggested, overlook other crimes that pose a danger to public safety. And so, for example, the crime of attempted luring of a minor or attempted child molestation in the third degree are crimes that, from my standpoint, are quite concerning from a safety standpoint, yet they would have bail capped at the $200 level, with a presumption that a person could bail out for about 1/10 of that, translating to the $20 I mentioned a moment ago. Last but not least, the proponent's data is not Washington state specific. This was a concern that WAPA brought forward to the state Supreme Court in relation to the indigent defense revisions that were made previously, which largely were based upon data from around the country, but that was not Washington state specific. And because our state constitution is fundamentally different from others, and the law of the land is different here as compared to in other states, prosecutors feel that it's most appropriate to look at state-specific data as compared to relying on national data, which may not translate very well to our circumstance. Finally, the proposed amendments that were brought forward were not subjected to the proper rulemaking process under the state Supreme Court's own rules. And so for that reason, we objected and have asked the court to take a closer look at what's before it. Probably within the next 4 to 6 months, we'll know whether the state Supreme Court is going to adopt those proposed bail reform measures. And if so, we'll see how that plays out at the local level. In the remaining time, I'm going to switch gears to a different topic that's I think largely misunderstood, but pretty important for people to know about, and that involves the plight of forensic testing in Washington state as applied to Clallam County. And so the slide before you has three columns. On the left, we've got law enforcement agencies uh, designated as jurisdictions. And so CCSO is the Sheriff's Department, PAPD is Port Angeles Police, SPD is Sequim Police, and State Patrol. FPD at the bottom of the slide is Forks Police Department, for which we don't have any data, and so I'm not able to report that. The next column, it identifies the number of cases that are pending toxicology through the state tox lab. And so these are cases where the men and women of law enforcement have seen fit to apply to a judge in the field, oftentimes in connection with a impaired driving investigation, and obtain authorization to have blood drawn from an individual's arm, which is then collected as evidence and sent to the state toxicology lab for testing. The testing is really important for prosecutors and for defense attorneys in courts because blood tells a story regarding what is present in an individual's system, be it ethanol, cannabinoids, amphetamines, cocaine, you name it. And so, as you can see, there's a number of cases that are currently in the process of being tested. There are 35 for the Sheriff's Department, 38 for PAPD, 8 for Sequim Police Department, and 111 for Washington State Patrol. And so in total, I think that brings us somewhere north of 190 cases that are currently waiting to be tested and have results sent back to Clallam County so that we can then prosecute cases. We also have a number of cases that are pending drug analysis through the state crime lab. This is through the materials analysis lab. And in particular, the Sheriff's Department has 14 cases that are awaiting testing. PAPD has 12, Sequim PD has 5, and State Patrol has 6. And so the reason I talk about this is because it's not uncommon that people will read about an individual being arrested on suspicion of driving under the influence, for example, and law enforcement will show up when called. They will investigate the matter. If they have probable cause to believe that an individual is operating a motor vehicle while impaired, they will effect a mandatory arrest under state law and book them into the county jail. And so everything's working the way that people would normally expect up until this point in the process. Under court rule, they are required to be seen in court the next regular court day. And so if somebody's arrested, say, for example, on Sunday afternoon, they have to be brought up to court Monday, which is the next regular court day. The challenge for prosecutors around the state is that in circumstances where the DUI investigation hinges upon the results of the blood test, which we're not going to have back for a period of time ranging from 10 to 20 months, and that's the current backlog that exists, we're really not able to charge the case knowing whether we're going to be able to prove it. Should we charge it not knowing whether we can prove it? Number one, we set ourselves up for failure from a timing standpoint because the speedy trial clock starts running. And number two, we can invite some ethical trouble if we're in a position where a judge finds that there's no probable cause to support the case, for example. And so the takeaway here is that I think public expectation is that when law enforcement respond and arrest someone for suspected drunk driving, for example, or for being in possession of drugs, that there's going to be a swift turnaround in the prosecution. And the reality is that because we are at the whim and mercy of the state tox lab on the one hand and the crime lab on the other, and we have a backlog at the tox lab anywhere from 10 to 20 months, and at the crime lab closer to 20 to 30 days, there's delay that is interjected. And so I know that that is frustrating for individuals. I can't change it. However, I can explain why that's occurring so folks are at least aware. The state legislature did take some action through the latest session, ostensibly to help what is occurring around the state in addressing this backlog situation. In particular, they passed a law that expressly authorizes local governments, counties and cities, for example, to use private labs to conduct testing that would otherwise occur at the state toxicology lab or the crime lab, just the toxicology lab, so long as the private lab is essentially certified or credentialed at the same level required for the state tox lab. And while this sounds like a good solution, the challenge exists in that the measure passed with no appropriation. And so the legislature essentially told counties and cities officially that they can do what they've had the ability to do all along, which is to hire a private lab to conduct these tests, but no money was provided to pay the cost of the testing, which is substantial. And to give you a sense of what I mean by that, in speaking with other elected prosecutors from around the state who've gone the distance to use a private lab for testing in a case involving a blood draw that went to trial, the price tag has been quoted as somewhere between $10,000 and $20,000 per case. We simply don't have that sort of money available in our budget, nor do I believe any of the local cities do. And so this is more of an academic fix that has been passed by the state legislature that comes with no money to actually address the backlog challenge presented. Next, I'd like to shift and talk a little bit about prosecution on a more fundamental level, just because I'm sensitive to the fact that it's not your garden variety job that most hold. And if you don't work within the criminal justice system, you don't have good reason to really understand what motivates prosecutors to charge cases and to decision make in the manner and fashion that they do. And so prosecutors in Washington have been delegated tremendous power by the citizenry. We are not a grand jury state. Instead, a prosecutor can subject anyone to criminal charges and possible arrest and jail based solely on our signature. And so what I remind folks in your county prosecutor's office is that the power to prosecute is, in many respects, the power to destroy someone's life. And the reason I say that is because if you take, for example, a particularly damaging allegation, say an allegation of sexual assault, once a prosecutor decides to charge somebody with a sex offense, that charging decision becomes a matter of public record. It is available for the world to see. And I am mindfully aware of the fact that while prosecutors perform their work in a court of law, at each given stage of a proceeding, there is a separate discussion occurring in a court of public opinion. And when we charge someone with a crime, even though there's a legal presumption of innocence, it's not at all uncommon, especially given the way of the internet, that there will be a chorus of feedback and judgment provided to an individual who's deemed innocent until proven guilty in the criminal justice system, but is being treated differently in a court of public opinion. And so we stick to the regulations that provide guidance to us in exercising prosecutorial discretion. On the one hand, we have ethical guidance that requires us to refrain from prosecuting a charge when we know that there's not probable cause to support it. We also are very mindful of some statutory guidance that exists in state law. And I've excerpted a portion of the statute at the bottom of the slide here, which reads, crimes will be filed if sufficient admissible evidence exists, which, when considered with the most plausible, reasonably foreseeable defense that could be raised under the evidence, would justify conviction by a reasonable and objective fact finder. And so there's a lot that is packaged into that statute. And I'll come back to that in just a moment. In addition to our ethical obligations and our statutory guidance, we also pay close attention to our burden of proof. And this is an area where I think there's some misunderstanding, largely because law enforcement operates in many respects focusing on probable cause. And if you look at the pyramid depicted before you, probable cause is the blue box second from the bottom. Our burden at the state level when it comes to prosecution is to prove each element of a crime charge by proof beyond a reasonable doubt. And that represents the small purplish colored box at the very top of the pyramid. Why is this structured as a pyramid? Well, because as the level of proof required rises, the fewer number of cases ultimately wind up meeting the burden. And so for that reason, there are a number of cases that are referred by law enforcement, reviewed by us, and not charged for good reason. And so when we go through the act of reviewing a case to make a charging determination, there are a few key things that we consider on a case-by-case basis. Number one, we consider the law and what are the elements of the offense. These are usually enshrined in state law, say a statute, sometimes as supplemented by case law or judge-made law. With respect to the individual facts of the case, we look to see if there's a known suspect. Sometimes we know that a crime occurred, but law enforcement is simply not able to identify who is responsible for it. And obviously, if we don't know who did it, we can't charge anyone with a crime. Was the crime witnessed or recorded? That can be invaluable, given that so many people in today's day and age have cell phones and use them. There's probably more photo documentary evidence and video evidence out there than ever before, and not just at the hand of citizens, but also law enforcement, who in many cases are now wearing body-worn camera that captures everything live through the course of an encounter. And so what I remind my trial deputies is that to the extent a picture speaks 1,000 words, just imagine the power of video, which can be helpful for prosecutors and for criminal defense attorneys, frankly, when it comes time to sit down with their client and talk about whether they have a viable defense to the charges before them, based on the fact that they might have been caught on candid camera. We also look to see if facts are disputed. It's not uncommon that we can have multiple witnesses to an event who all relate something different that they observed. And the difference is what defense attorneys tend to focus on for good reason, because if one person, say, for example, described a getaway vehicle as a white Ford Bronco and somebody else described it as a red Pinto, and sometimes we do have testimony that it's that extreme a departure, that can oftentimes rise to the level of reasonable doubt in relation to the state carrying its burden. We also look carefully at the evidence to consider whether it's direct evidence. Is it something that somebody saw with their own two eyes or heard with their ears? Or is it circumstantial, evidence from which, based on common sense and experience, somebody could reasonably infer something that's at issue in the case? If there's forensic evidence, that's great. However, for the reasons previously touched on, there may be a backlog existing at the state lab that prevents us from coming into possession of the evidence for anywhere from 10 to 20 months, which can really delay justice in many cases. Most importantly, we don't just look at the evidence, we look at whether it's admissible. And so if it's not going to be admissible and never get to the jury, it's of little utility to a prosecutor. And so we tend to discount in our charging consideration inadmissible evidence and then see what's left to determine whether we have a provable case. Defenses that are commonly raised include self-defense in certain circumstances, alibi, when an individual says it could not have been me, I was in a separate location and I have a witness who can prove it. Insanity can oftentimes be raised, and duress. In other words, I only committed the crime because I had no other choice. I was being blackmailed in some nefarious way, for example. And I'm going to wrap up by just touching on criminal appeals. I will note that they exist to allow a higher court to review a lower court's decision. They can correct legal errors made by judges, attorneys, or court procedures. They are important to safeguard rights, constitutional rights in particular, and they help to ensure uniformity so that laws are being consistently applied across the state of Washington. There are two main types of appeals. On the one hand, direct appeals, which exist as a matter of a right for final judgments. That would be somebody being sentenced in the aftermath of a guilty verdict in a criminal case, for example. Direct appeals are generally limited to the trial court record. So anything that was admitted into the record through the course of a trial proceeding would be fair game to argue on appeal. Personal restraint petitions, or PRPs, by way of comparison, are for claims outside of the trial court record. And so the best example I can provide for this would be the work of groups like the Innocence Project, who, with the advent of technology involving DNA and forensic genetic genealogy, are now able to develop evidence that can prove that somebody who was previously convicted was wrongfully convicted, in fact. And so they're able to argue evidence from outside the record that was not known to the trial court or counsel at the time of a guilty finding, and use it to have convictions overturned. We've tracked our appeal data pretty closely in Clallam County, and for the full 10-year period from January 2015 to December 31st, 2025, Clallam County had 104 direct appeals and 15 personal restraint petitions filed. Criminal convictions were upheld in 109 cases, or 92%. Convictions were reversed in the remaining 8% and remanded for new trial. There were a number of discrete issues taken up on other appeal matters, maybe involving the amount of legal financial obligations, but those didn't affect the fundamental conviction itself. And so appeals are a vital check and balance in the criminal justice system. If you'd like to learn more about any of the data presented today or about the prosecutor's office, you can go to the county website, navigate your way to the prosecuting attorney's link, and you'll find your way to our website, where we have quite a bit of information presented for public consumption. And I always like to end with a fishing picture, because some of this content is pretty serious, and this is how I clear my mind, and it's the functional equivalent of, I think, my therapy, given the work that I do.
Man,
And
that's a hog. Where'd you catch that at?
that's a spring king caught on the Solduck River.
Nice. Out west. It's
Yes,
awesome.
out West Clallam County, my heaven on earth, and the place I go when I need to clear my mind.
That's awesome. Well, great presentation. Thank you so much. We do have a question in the chat if you're open to taking questions.
Absolutely. I'm just going to try to see if I can get back to the chat here.
And I can read it to you while you navigate.
Sure.
Paul Gottlieb asks, what are your plans for the next 4 years as the prosecuting attorney's office? At the prosecuting attorney's office.
Here we go. Okay, now I can see everyone again. So there are a few, Paul, thanks for your question, wherever you are. There's a few areas of emphasis that I'll be focusing on as we move forward. I've done my best each term I've been in office to try to stay as connected as possible with the community. And so having the opportunity to present before this group is a good example. I also try to make the rounds with local service clubs, Kiwanis, Rotary, Chambers of Commerce, you name it, and listen carefully to the feedback received. And so one of the areas where I'm going to be focusing involves repeat offenders. We've all heard about them, and case in point, there are a small subset of offenders who I think consume a disproportionate amount of criminal justice system resource, and who work disproportionate harm on public safety within our communities. And so this is a group of individuals that I'm going to be focusing on, really bringing to bear all of the legal tools available to prosecute them in a way that is going to ensure accountability, if necessary, remove them from the streets to the benefit of otherwise law-abiding citizens. And so for some people, jail is the right place for them to be. That's one area of emphasis. I'm also quite concerned about the direction of state law in relation to the treatment of crime victims and survivors. And so there has been a growing focus on the rights of the accused, and at times I feel that has come to overshadow crime victims' rights. And so for ordinary law-abiding citizens who are just going about their life and who wind up being victimized by crime, it's bad enough that something happened to them to begin with. I really don't like the notion of them being victimized for a second time by being put through the criminal justice system. And so doing things a bit differently to try to elevate the rights of crime victims within the local criminal justice system is something that's very important to me. A third area where I have heard loud and clear from citizens from across the spectrum that we have a problem, and I would characterize it that way in my own terms and in my observation, is in relation to drugs. Every county has a drug problem. I'm not going to shy away from that. However, it seems to be the case that we have been disproportionately hard hit over the years. If you look at state data reflecting fatal overdose rates over the last, say, 5 to 6 years, there have been times when Clallam County was, I think, in the third place position out of the 39 Washington counties, uh, which is a bad place to be. What that speaks to is we have a lot of people who are probably using drugs and dying from drug use. When it comes to recreational users, there's only so much that we can do through the criminal justice system. When it comes to dealers, that's an area where we can focus our efforts. And so I have long been a supporter of our regional drug task force. I always have an attorney who's been embedded with it as an asset, and we're going to continue that. And I think focus much more aggressively on prosecuting using all tools available drug dealers. So the individuals who are actually bringing the product into our county, if we can prosecute them, remove some of them from the community, stop the introduction of contraband into our communities, I think that would be a benefit. And I'd like to do it in a way that hopefully starts to create a reputation for others who might be inclined to come here and deal drugs, that this is not a friendly environment in which to do that. And so, Paul, those are three areas of emphasis that I'll be focusing on over the next 4 years.
Great. I have a two-part question. At the local level and at the state level, managing budgets has definitely been a hot topic. How is your office managing your staffing limits while also maintaining public safety? And then the second piece of that, what criteria determines what cases you prosecute versus divert?
Sure. So in relation to the first half of your first question,
Yeah.
we have like many Washington counties and cities, frankly, we have been struggling to attract and retain attorneys over the last really 5 years or so. This started just prior to the pandemic. A lot of people like to point to the pandemic and say that's what's responsible for all this, but the data reveals something different. It was the year before the pandemic occurred that we started to see a reduction in qualified applicants, and frankly, fewer applicants overall. And that has really been the story of certainly Clallam County for the last 5 years. I do have some good news to report, and that is that, frankly, it may just be by sheer luck. We have two highly qualified attorneys, trial practice attorneys with 5 and 6 years of experience, respectively, who have applied, accepted contingent offers, cleared background. One of them will be starting July 14th. Another is going to be starting September 1st. And so with the introduction of those two criminal practitioners, our criminal division will be, from my standpoint, almost fully staffed. And so that's going to be, I think, something that will make a positive difference in relation to how quickly we're able to turn certain case types around. In response to the second half of your question, Mitch, the slide that I spoke to earlier that speaks to ethical constraints on prosecutors, the statutory guidance that we have regarding when crimes are to be filed, really guide the exercise of our discretion. Above and beyond that, we also are routinely faced with needing to work with human beings, survivors, victims of crime, who may have strong feelings about cases being prosecuted or not. And in many cases, while it's the state's decision whether to proceed forward, we do take into account the wishes of survivors and crime victims. Oftentimes, that's why we'll plea cases down to an ulterior resolution to prevent it from needing to go to trial. Uh, but my goal is to, frankly, charge every case that we can prove. That's always been our goal. We like to get our ducks lined up in a row first. We work with the men and women of law enforcement to fortify their investigative techniques and practices. And so I think through that collaborative interaction, we'll do the best we can in that regard. Our charge rate is, it's about 60% or so, which some people hear and say, well, that seems low. And my response to that is low in comparison to what? Because if you simply characterize it as low without any comparator, you're really not doing a service to the narrative. As I've looked around other Washington counties, number one, it's been frustrating because there are very few that publish data in the same way that we do through the county prosecuting attorney's office website. The only three other counties I can find that publish data are King County, Pierce County, King County, Thurston County, and I believe Snohomish County. And when I went through Snohomish's data dashboard recently and crunched the numbers, what I found is that they too have about a 60% charge rate. And again, I don't think that's representative of anything going wrong, especially when you consider the disparate burdens that prosecutors have vis-a-vis that of law enforcement when it comes to effecting an arrest based on mere probable cause. Again, we need to go quite a bit further and be able to prove each element of the crime charge by proof beyond a reasonable doubt.
Good. No, that makes sense. Just one more question and then we'll wrap. Ed asks, how do you see the office's workload being impacted by the change in the coroner's position in the county? In terms of, do you see that change giving you an opportunity to address those 4-year goals you pointed out?
Absolutely. Ed, thanks for your question. I noticed, well, almost immediately when there, in the aftermath of a change in state law and an attorney general opinion interpreting that in a way that required me to step away from the coroner function, which I'd been doing for years, I noticed immediately how much additional time I had to focus just on the prosecution function. And so I don't think, frankly, until I stopped doing the coroner work, I realized how much time investment I was putting into it, trying to run two offices simultaneously. And so it has allowed me to get back into court personally, which has been really enjoyable. That's how I started as a criminal trial attorney and then transitioned to civil practice. I try to cover the felony fresh arrest dockets as often as I can, Mondays through Thursday in Superior Court. Anybody's welcome to watch that via Zoom. It's streamed live each day, and the ability to focus on one versus two offices has definitely been helping in relation to the work of your county prosecutor's office, and I think it's going to pay forward in dividends when it comes to me remaining laser focused on the three areas, among others, that I mentioned earlier in today's discussion.
Great. Thank you so much for your time, Mark. You got a few people in the chat calling it a great call and thanking you as well. It's 9:02, so we'll go ahead and wrap at this point. But as always, great presentation. We appreciate the work you do, and this recording will be up on our website later today.
Great, wonderful. Thanks, Mitch. Thanks, everyone, for sharing some time with me. I hope you each learned something that you may not have before.
Absolutely. Thank you. Everyone.
Hey, Mitch,